Good day, family. It's been a while. Doing this live broadcasts, and I felt the necessity to communicate with you and make a commentary on this Section 22 out of committee matters, especially this issue on their draft document and things like that. But now on this, conversation, I will be dealing with the part one of our conversation. And in this part one of the conversation, what I'll be dealing with is for us to look into what the Constitution is saying about the CRL, as well as what the CRL Act is saying about the CRL Commission. So just follow, as I'll be looking at those aspects. So my reference for this part of the conversation will be more from what the Constitution is saying. And secondly, what the CRL Act is saying on, these matters, because I feel it's very much important for us to understand, before we deal with the Section 22 committee and what is all about that draft document, to really, have an understanding of what is the CRL in terms of what the Constitution is saying, and secondly, what the CRL Act is saying. And, I'll be later on, attaching some links so that whatever that I'm saying, then you can verify it by looking it into the Constitution. But if you have a copy of the Constitution of the country with you, and you can still have it by going to Google, type South African Constitution PDF, so that you get a PDF version for yourself of the Constitution of the country, so that it will be easy for you to follow as I'll be reading and referencing from the Constitution, so that you verify. As well as if you are looking for a copy of the CRL Act, you can still go to Google and download it, download that copy of the CRL Act from Google, so that as I read, we can be on the same page. One of the things that I do is that in the space of training, and in training, we speak of what is called active learning. So I would want us to learn actively as to, so that you follow. You don't just take my word for it, but see it for yourself. Yeah, I see you, Nozipo. Yeah, I saw even Bishop Kelly earlier. Hey, welcome to this conversation. Now, my point of departure will be looking at what is the CRL in terms of the Constitution of the country, the CRL Rights Commission in terms of the Constitution of the country. Now, why is it important to understand that? Because, if you read in the book of Hosea, chapter 4, verse 6, it says, "My people perish for lack of knowledge, and because you lack knowledge, therefore I will reject you as priests," meaning my representatives before the people. And in the book of Malachi, he was saying that, something important to say: the lips of a priest should preserve knowledge, and people must seek, knowledge from the lips of the priest. Now, if we are the Church of God, kingdom people, we are called, according to the scriptures, that we are a kingdom of kings and priests. So we have a responsibility as the church to make sure that we gain knowledge and understanding of things, because I see a trend, with our people, as these matters are being shared, especially on mainstream media, sometimes, anchored by journalists who don't do their homework, a proper homework, who haven't taken the time. I can say so because when a person speaks on issues, you can tell if they've done a homework to really study the content that they are dealing with or not. You listen to the quality of journalism and the quality of questions that are asked, especially asking the CRL. The previous time I was disappointed, listening to Dr. Maloma, and I'm like, hey, my honorable doctor, hey, yeah, you wonder some of our credentials, especially when a person holds a credible, PhD. You even doubt, if what happened. So it's a problem. But anyway, I'm not there. But I'm saying, don't just follow what you find on TV. Just because something appears on TV and is said to be said by people who are experts or people who are having certain credentials or holding certain public offices, just because it's on TV, it doesn't mean it's factual and truth, because there are all reasons why people are on TV and media and so on. That's why for everything, that you consume on television, verify it, with fact check it yourself. And by studying, reading, referencing from the same reference, like as I'm saying in this conversation, I'll be referencing from the Constitution so that you see it from the Constitution, as well as the CRL Act, what the CRL Act is saying. And you can fact check me, by checking the Constitution and the CRL Act to check if what I'm saying is it so in terms of the Constitution and the Act or not. Because some of the times you are told, no, like for an example, we are told that Section 22 ad hoc committee was founded or constituted based on Section 22 of the CRL Act. But if I may ask a question, generally, how many of us have, took the time to go to that act, the CRL Act, check exactly what Section 22 of the Act is saying before just accepting, what we were told as gospel truth to be so? Then you will see why you will follow my thoughts as to why I call it a bogus Section 22 ad hoc committee. Why am I calling it a bogus? Is because that Section 22 was not followed to the letter. It's a wrong application. And then if I were to advise the commission, I would show you within the act what they could have done. They just picked a wrong section to try to achieve something and, applied it wrongly. But we'll discuss that. Let's start first by understanding what the CRL is all about in terms of the law, the Constitution, and the Act. Now, CRL Commission is part of, you will find its placement in what is called Chapter 9 of the Constitution. The Chapter 9 of the Constitution. Now, if you want to reference where I'm at, if you have downloaded that chapter or that Constitution as I requested, as I began the conversation, it's on page 92 of that document. So page 92, that's where you'll find chapter 9, chapter 9 institution. So CRL is part of the chapter 9 institutions. And there's the topic of what are chapter 9 institution. Why are they called chapter 9 institution? It's because they are on the chapter 9 of the Constitution. As you page and reference the chapters, you'll arrive at chapter 9 of the Constitution. And here's the heading of all these Chapter 9 institutions, they are called state institutions supporting constitutional democracy. Now, when you read section 181.1, and then you will see their alphabets A to F, which speaks to Chapter 9 institutions from the Constitution. And then you will see 181.1C. That's where CRL Commission is located, meaning that CRL, it's called a state institution, which is something I want you to bear in mind, that when you are dealing with CRL, you are dealing with a state institution. It's not a body somewhere in the corner. You are dealing with an institution of the state. And as an institution of the state, it is said, like other state institutions, to support constitutional democracy. And there in 181.1, it says the following state institutions strengthen constitutional democracy. That's the first thing you need to understand when you're dealing with the CRL, that you are dealing with the state institutions. And, you know, the aim of the state institution, which is the CRL, is to strengthen constitutional democracy. Now, let's go to now 185, because section 185, that's when now, and 186, that's when now the Constitution is placing the CRL and what the CRL is supposed to do. Now, when you go to section 185, 185 and 186, in 181.1, the heading there speaks of functions of the commission, meaning this is what the Constitution expects this state institution to do, or why was it there, or why is it there in the first place. It says the primary underline objects of the commission for the promotion and protection of the rights of cultural, religious, and linguistic communities are, number 1A says, to promote respect for the rights. So CRL is there to promote respect for the rights. The rights, which rights? The rights of cultural, religious, and linguistic communities. CRL is there to promote respect. It means now CRL is there in its role to strengthen constitutional democracy. It's there to ensure that the rights within the context, of the religious sector, the rights of the religious sector, or religious communities are respected, to promote respect, meaning people should not undermine the rights of religious communities when the CRL is there. Once people disrespect the rights of religious communities, then you will know that the CRL is failing in its role, the reason why it was formed. And secondly, to promote and develop peace, friendship, humanity, tolerance, and national unity. And national unity is to promote. They must promote. When you see CRL step into the place, you expect that it will promote, not only promote, but develop peace, meaning where there are conflicts within the religious sector in this context, CRL will step in to promote and develop peace. It will step in to develop friendship and to develop, promote and develop humanity, tolerance, and national unity. Now, when CRL step in a place and there's conflict, people start to, it agitate or instigate people to be in conflict. It promotes conflicts. There's no friendship promoted within the communities. There's no humanity, tolerance, and national unity. If there's division, if CRL divide the people, then that is not fulfilling its mandate. The other thing, which is within the Constitution, it says to recommend the establishment or recognition in accordance with national legislation. By national legislation there, it refers to the CRL Act, is to recommend the establishment and recognition in this sense of religious councils, or religious councils in this sense. Now let's check before I can continue there. Go to the Act, because some of the things, the Constitution gave us a summary, but there at the Act, in the Act there, the CRL Act, as I asked that we download it, in terms of why do we have it in the first place? Why is it there? Why is the CRL Rights Commission there in the first place? Then let's continue to explain these things from the Act. And in the Act, on those objects, or the reason why the CRL is there in the first place, you will see it in section number 4 of the CRL Act. It says the objects of the commission. It repeats what you saw in the Constitution in 185. You would have seen there the A, which speaks to respect for, and then it extends by say for further protection of the rights, and it speaks of developing, promoting and developing peace. And now there on the C of section 4, it says to foster mutual respect, among cultural, religious, and linguistic communities. And it says to promote the right of communities to develop. Here's an interesting one. It says to promote the right of communities, religious communities, so that the religious communities should develop their historically diminished heritage. Now the E of the X, it's like the C from the Constitution. It says to recommend the establishment or recognition of community councils. So this is basically the object. After CRL has done a good job, these are the outputs. These are the things that we need to see and expect from the commission. Now from the Act itself, now let's move to section 5 of the Act. Section 5 of the Act, we have 1 and we have the 2, but I'll be looking into 1, but you can look on section 5 as a whole, 1 and 2, because of in terms of time management. But you can reference, and if you have questions, you'll just type them on your comments as we go on some of the things that you would see from the Act that I might skip and so on. I'll be ready to answer any question on this matter. Now if you look into section 5, 1 and 2, now it deals with the heading there, speaks of the powers and functions of the commission, meaning these are the powers that the CRL Rights Commission has, and as well as its functions. Now you look into them, especially on section 5.1a up to K. Now you'll find something interesting there. The first power and function they have is to conduct information and education programs. So because in the context of religious sector, CRL must conduct information and education programs. That's what they are empowered to do. But if I may ask most of us, how many of us have been to information and educational programs of the CRL? We should ask something, because this is why they are there in the first place, to conduct information and educational programs. The other thing, conduct programs to promote respect for and further protection of religious communities. When did you remember the CRL conduct programs that promote respect, where it's like the CRL, like in this context, will teach you? There's a program there that will teach you on, how to respect, and further protect the Christian faith, or any other religious community. The other one, it says promote awareness amongst the youth of South Africa of the diversity. When have you ever heard of an awareness campaign to young people on religious matters? And that program is run by the CRL. This is their power and what they are expected by the Constitution and the law to do. But when have you ever seen this happening? The other thing, it says, what is their power and their function? It says is to monitor, is to investigate and research any issue concerning the rights of the religious communities. Who has ever, maybe monitoring, but their monitoring is done by television. It's sound bites on television. But monitoring in terms of investigating, a thorough and proper investigation, not this, shortcuts called investigation. We have investigated, and you listen to the quality of what is called an investigation, you find a lot of questions. And also research, you check the research and you wonder, hey, research, nay. Yeah. But what shall we say? And here's another one. It speaks of to educate. Where has CRL taken the time to educate, to lobby, to advise, and report on any issues? The other thing, to facilitate the resolution of friction. Facilitate. I'm a facilitator by qualification. When you facilitate, you listen more than you speak when you facilitate. But unfortunately, what I've observed, CRL is doing a lot of talking than listening and facilitating. And again, receive and deal with requests relating, to receive and deal with requests. And here's another one, the key. It says, make recommendation to the appropriate organ of state regarding legislation that impacts or may impact the religious community in this sense. I will want to emphasize this one because of what is happening currently, the things that are happening currently. Now, on matters of legislation, what the CRL is expected to do in terms of the Act is to recommend. They should recommend to the appropriate organ of the state regarding legislation that impacts or may impact the religious community. Now, in this sense of the Constitution and the law, they are on matters of the organs of the state which are responsible for legislative issues are your parliament, your parliament, as in the National Assembly, the provincial legislature, and the municipal council. Those three bodies on issues that have to do with legislations. Those are the three institutions that are empowered to deal with legislative matters. Now, the other aspect, the J speaks of establish and maintain databases of cultural, religious. So in this sense, is to establish and maintain databases of religious communities. And the K speaks of bring any relevant matter to the attention of the appropriate authority or organ of the state. Now, they are to bring matters to relevant state organs and, meaning competent places. There are certain matters CRL cannot deal with, but when they see them, they must, take them to the relevant, competent institutions of the state. Some things need the police. They must take them to the police. Things that need your NPA to deal with, take them to NPA. Things that needs the courts, take them to the courts. Things that need home affairs, refer them there. Some things need some of the Chapter 9 institutions because CRL doesn't have the power, over certain things. They should reference those things to those bodies. So that's basically. Now, here's an interesting one. If you read this act, the CRL Act, there's no way in the act where CRL is empowered or is given the function, of regulating anything. CRL regulates nothing. At best, it educates. At best, it investigates. After those investigations, it recommends. It recommends. Its work is to recommend. After they've done their homework, they are like, oh, we do our homework. What can we do? Okay, the solution will be, in this regard, the best tool is to educate. The best tool is to lobby. The best tool here is to, be a mediator when there's tension amongst the sectors and the people. Let's resolve matters where there's tension and so on. But we should not instigate hatred, but promote peace and things like that. This is what the Constitution and the CRL Act expects the CRL Commission to do. But in your observation, which of these things have highlighted? They are there in black and white within these two documents. They are there in black and white. Now ask yourself, when do you remember CRL playing that role? Playing these roles that are there in black and white in the CRL Act and the Constitution. Now, like I'm saying, that the best that has to do with legislation, that is section 5(1)(I), where it says they can recommend to the organs of the state or the organ of the state that has to do with legislation. In this sense, is parliament or provincial legislature or municipal council, depending on the context and the nature of the legislation that is needed. Now, there's no way CRL is being tasked with the responsibility of regulating anything. And the other thing that we need to note that I have highlighted on section 4, section 4E of the CRL Act and its C of the Constitution, is to recommend the establishment or recognition of community councils. Community councils, if we want a council and so on of something, the extent to which the CRL can go is only to recommend, is to recommend the establishment, not to establish. CRL is not empowered to establish a community council. So I will delve a lot when I'm dealing with part 2, where I'm zooming into the Section 22 committee so that I show you where the error of the CRL is. Where I show you the error of where the CRL got it wrong. Where it got it wrong. It's not there to establish anything. It's there to recommend and recognize. To recommend is to say, guy, I think on this, you can do this. Not to say, I tell you, you are going to do this by decree. It's not to pontificate. For those of you who like big words, it's not to pontificate. It's not to tell you, this is what is going to happen. You will have this body, this community, because community council includes, even what they said they want to do and so on. Okay, fine. It's to recommend and to recognize, meaning if you have that council, in this sense, which is a religious council, or maybe you have an organization that you have started, and you want recognition from the CRL, the CRL's job is to make sure that, okay, this is a legitimate body, we recognize you. And where this, you'll see as we continue, where it speaks of, I think we can go there, where it speaks of provisions that deals with this community councils. Let's look at that section. We are still on CRL Act section, and let's hear what the Act is saying on the formation of community councils. Let the Act speak for itself. Let it speak for itself, and then that is, where are we? From the Act, yes, that's a heading there. In the Act, it's written Part 7, Community Councils. And then the subheadings there on Section 36.1 and Section 36, the subheading there says Recommendation of Establishment of Community Councils. Now, before we get there, let's go to Section 1 on definitions so that we get to understand what does the Act mean when it says a community council. What is a community council according to the Act? According to the Act, when you go to Section 1 of the Act, it says a community council means a voluntary association of persons. Underline, voluntary. It's a voluntary association of persons or community organizations based on the principle of freedom of association, and which represents, meaning that voluntary association of persons or community organization, it's run on the principle of freedom of association, and then that community represents either a cultural, religious, or linguistic community, and includes, a cultural council envisaged in 181, as we read it, 181 1C. There. Now that we understand, according to the Act, Section 1, what the community council is, it says these are your voluntary association of persons or community organizations, like your fraternals and so on. Those are community organizations. Those are voluntary associations. They are voluntary. You volunteer to be part of them. Now let's go back to Section 36 and see what about what business, that Part 7 of the Act. That Part 7 of the Act, so that we understand what are these things. What's the business with these things? Is there. It says recommendation, meaning this Act tells the CRL Commission on how to go about recommending these voluntary associations and organizations. It says in one of section 36, it says persons belonging to a cultural, religious, linguistic may form. Persons may form. They may form. The persons, these persons who want to be an organization, they are the ones who may form, not who must form, who may form. Because it's voluntary. That's why the language of the act says may. You may or you may not. It says they may form. Secondly, they may join. You are not forced to join. You may join because it's voluntary. And thirdly, and maintain. In this context, the religious associations. You may form that association. You may join the association. If you don't want to form it, you may join the existing one and also maintain it. You people, you persons who want to form, the persons, not the CRL, but the persons may form it. It's not the CRL that must form these things. It's the persons, voluntarily so, who may do so. And then it says, as envisaged in section 31 of the Constitution. So you see there in section 31 of the Constitution where it says you may form and so on. So this is a point taken from the Constitution to say you may form. So you are free to form a new organization and look for recognition in the CRL. But now on section 36, I was reading one. Now here is where the CRL come in, where issues of community councils coming in. By the way, the act is saying the CRL may recommend what? Recommend that persons belonging to, in this sense, the religious community, the persons who belong to the religious community may form. CRL may recommend that you can form, you can join or maintain. That's how far they can go. They recommend. And then 2 says the commission may recommend to a community which is not organized to initiate and establish a community council at provincial or national level if establishment of such a council will be conducive. Now, there are those organizations where now maybe they are not organized. CRL may recommend to say, guys, we see you have interest in these matters. Please form a body, that will speak to the issues that you are raising, and then that's where you will see it in A and B there. In A, it says maybe you are interested in promoting and protecting of rights of such a community. If you want to protect the rights, of the faith or the religion you are in, CRL will tell you, hey guys, the rights of your community are not attended to. They are not receiving attention because you are disorganized. Establish a body, we recommend, do something about it so that your rights, are attended to, receive their attention. And secondly, you want to promote peace, and friendship and humanity, because it's about nation building. If you're interested, form a body. But that's how far they can do. They are not to establish. CRL must not. It is not mandated to form, or to establish any community council. If there's a religious body and the CRL is involved in its establishment, then the CRL Act is violating the very act, according to section 36, of the act. And now section 37 speaks of, how do you get recognition from the CRL? The guideline there on 37.1 says a community council envisaged according to section 36, 1 and 2 may, in prescribed manner, apply to the Commission for recognition. Meaning, if you want to be recognized by the Commission, you can apply to the Commission so that they recognize you. But, in a prescribed manner, they'll tell you, these are the qualifiers, so that you can be that type of a community council that is aligned to them in terms of the act. You see, and now, yeah, you see, now, if you go to 38, you'll see something interesting. And if I were to advise them, they shouldn't have opted for Section 22. They should have used Section 38 or 36 to 38 to want to do this thing. But, even with the criteria and so on. But unfortunately, they used 22, wrongfully so. Okay. Now, because last time I was discussing this aspect with Dr. Mafaza, the CEO, he said, no, but guys, it was for financial reasons that Section 22 was done, so that we fund the processes and so on of consultation and so on, and issues like that. Anyway, we'll delve into that on the part 2 of this conversation. But I'm saying this is what, as far as forming, firstly, that issues of regulation are nowhere in the function of the CRL. Every time CRL wants to regulate, to language that has to do with will regulate you as the CRL and so on, that is not what the Act is saying, neither the Constitution. At best, what the CRL can do is to recommend. And when somebody recommends something, it's either you can accept it or reject it. It's not a must that the recommendation should be followed, because sometimes, advice is to advise, and advice can be followed or not followed. So whoever is on the other end of the advice received and the recommendation received is the deciding body to say whether we legislate or not, or whether we form this council or not. But they can't be saying we form a council for you and therefore you must be part of it. Now, here's something interesting, because we are clear on what I've raised. I spoke to the formation of the councils. I've spoken to the function, what the CRL is about, what is expected to do, the aspect of regulating and legislating. What they can do is to recommend. You saw there in Section 5, 1I, it says it recommends to the organ of the state, and the organs of the state dealing with legislation are your government, your parliament, your provincial legislature and municipal councils. Those are bodies. And now those are bodies that are competent and so on. And if there's something new they want to raise, because I want to wrap up this part 1. Because it's something I want us to see, but I believe we'll be looking into that. Here's something I want us to look at where Section 22 is concerned. I'll just highlight, but by the way, I'm dealing with the Act and the Constitution now. We are not zooming into that framework, and the Section 22 thing. We are looking into, the process. If there's legislation that is needed that impacts on aspect of religious communities, like I said, the competent bodies where legislation are concerned, meaning the recommendations of the CRL to legislate must either be sent to Parliament, and then according to Section 44 of the Constitution, because it's the body that's responsible for legislation, or to provincial legislature according to section 104 of the Constitution, or the municipal council according to section 116 of the Constitution. Those are the bodies. Now, in terms of process of how then legislation is dealt with and legislation must be passed, you see, the process, at national level, although the principle applies, to all these lower levels or spheres of government, but at national level, a person who can initiate legislation. By the way, I said CRL, theirs is to recommend legislation to an organ of the state, meaning a competent organ in the state. And in this sense, the competent organs of the state to deal with legislative matters or to receive recommendations that may come from the CRL. Number one is the National Assembly. Number two is the provincial legislature. Number three is the municipal council, because they are bodies that are competent. They are organs of the state with the competency and the jurisdiction to deal with legislative matters. Yeah, but in terms of initiating the process, now here are the people who can initiate the process, because one of the, another thing they can do is to go to the Minister of COGTA, to say, we have a need here, can you assist us here? Then, yeah, because why am I bringing in the Minister of COGTA is because if you will also look in section 40 of the Act, section 40 of the Act on issues of regulation. That's why I say the Commission does not have the jurisdiction and the power on issues of legislation, on issues of regulation. Now, if you want to know what the Act is saying about regulation, go to section 40. The heading there says regulations. And it says in section 40, the minister, not the commission, the minister, after consultation with the commission, may make regulations regarding any matter. It is the minister who can make regulation after consultations with the commission. Is the minister, who has the power in terms of the Act, to talk about regulation. But when you talk legislation, you are talking the language of the legislature, not the commission. The commission cannot legislate. They can recommend legislation. And the minister can deal with the aspect of regulations from the consultation that they've received from the commission. And the A, it says any matter, A, that may or must be prescribed in terms of this Act. If there's a matter that has to do with this Act, that needs the minister to intervene with regulation, the minister is the one empowered. The B says, and the minister consider necessary or expedient to prescribe, meaning when the minister must act, he must, satisfy himself in this sense, because he's a man. The minister must satisfy himself that this is necessary, the regulations are necessary and expedient, and then in order that the objects of the commission may be achieved. Meaning, whatever role the minister must play is in relation to the objects, those 5 things. That's when the minister can come in to make sure that CRL, can we help you with regulation that will help you so that you promote friendship, you promote respect, you deal with community councils, aspect of even financial assistance and so on. But I'll come into that and issues like that. That's why those are the issues that have to do with section 38. We'll come to that just now. as we are about to wrap up this first segment of this conversation. Now you will see there. So they can recommend the formation. They are not forming anything. They are not legislating anything. They are not regulating anything. If CRL establishes a body to say, this is a community, something for your community, maybe it's a religious sector, like we are going to form this thing, it's off the script. The script does not empower them to do that according to the Act. Right? Let's see, where are we? All right. Now let's go to the section 22 thing. Yeah, as I wrap up this discourse on part 1. Now, if you go, I believe you managed to download your copy of the Act, the CRL Act from Google, and your constitution, so that you can follow as we continue with the conversation. Now, you will see something now in about section 22, because there we want to qualify it from the Act as to what is this? What is the Act saying a section 22 is? Now, there's, in the Act, there is what is called Part 4 of the Act. The heading there of Part 4. Part 4 heading says Operation of the Commission, meaning the things that the Commission must do when it operates. When it operates. We've seen the purpose, the functions as to what they need to do, but as they operate this machinery, called the CRL, it speaks to the system side of the CRL to say how things should be done, how the CRL should do things. Now, heading, which is part 4, which is heading, the heading says Operation of the CRL or Operation of the Commission. Yeah, pardon me there. Operation of the Commission. Now, there are 1, 2, 3, 4, 5 things that have to do with the operation of the Commission. The first thing speaks about meetings, meaning CRL or the Commission in its operation, it must conduct meetings. And what is it that the Act is saying about meetings? You'll see it in section 19, where issues of how meetings, CRL should conduct meetings. You see it in section 19. And the second thing deals with procedures on how the Commission should deal with issues of procedures. You will see it in section 20 of the CRL Act. And how should the CRL deal with issues that has to do with decisions? Meaning, as commissioners are doing their work, how should they make decisions in their meetings? What procedures should they follow as the commission? Now, number 4 speaks of committees, meaning how should the commission deal with committees? In a sense that the commission wants to establish committees. What should they do if they desire to have committees? And number 5 speaks of delegation of powers and assignments or assignment of duties, meaning what should, how should the commission delegate its power if it sees him to do so, or maybe delegate certain assignments. They are there in the Act. Now, section 22 falls under the heading that says Operation of the Commission. So Now, this committee, the committees that fall under Section 22, they are committees that are operated by the Commission. They are the committees of the Commission. Inasmuch as meetings are the meetings of the Commission, procedures are procedures of, by the way, of, it speaks of possess, it speaks of ownership or responsibility. Those meetings is the CRL that has responsibility of hosting meetings. Nobody. Is the Commission that must have those meetings because it's part of their operations. Secondly, it is the Commission that must determine its own procedures. It's the Commission where issues of procedures, how things should be done. On decisions, the decisions that the Commission is, they are the decisions of the Commission. And even the committees, they are the committees of the Commission. And the delegation of powers and assignment of duties, it is the Commission delegating powers and assignment of duties. Now, Section 22 committee is called ad hoc committee. That committee is not an independent committee, is the committee of the CRL. That's the first thing we need to understand. It is not an independent committee. It is the committee of the CRL. It is not the committee, because once it becomes independent, from the CRL, once it becomes independent from the CRL, it changes to become, that community council. It changes name, legally speaking, to being a community council. It becomes, if it's independent, it becomes a community council in terms of the Act or in terms of the law. But as long as it is not a community council, it is a committee of the CRL. So that Section 22 people that were announced at the REMA, that's the committee of the CRL according to the Act. And if they say that group of people, they are independent from the CRL, then their status changes to becoming a community council. Because one of the things that the community council is to do is to advise the CRL on what needs to be done, is to consult people within the sector on matters and advise the CRL. Now, if that body is independent, it is not a Section 22 committee. It is a community council, if we were to label it correctly. But if CRL claims to say, no way, Nkosi, this is a Section 22 ad hoc committee, then we have a problem in terms of the Act itself. It says it's illegitimate, it's unlawfully constituted because, firstly, if the CRL applied this Section 22 Act to form that committee, the Act says that committee belongs to the Commission. And when Commissioner says it does not belong to the Commission, they have violated the very Act that they said they applied to form it. So, and if they say it's independent, it's a violation again. It means the commission has established a council, and it's a violation because of the E of the objects of the commission. Section 4E says they should recommend, and the act itself, it says their role where community councils are concerned is to recommend the formation, not to establish. So that committee was established by the CRL using the act. How do I know that it was established by the CRL, the section 22? Now, you will see as you read there. When you read section 22:2, before we get to A, I'll show you something from from section 22:1. But let's go to section 22:2. By the way, section 22:2 is part of section 22. Section 22:1 and 2 are both section 22 of the Act. So it's section 22:1 and section 22:2 of the Act. Now, let me read section 22:2 so that I show you that that committee was established by the CRL. It says true, according to the Act, the commission must, that is A. 2A says the commission must determine the functions of a committee. Meaning it is the commission that must, it's a must, it's not a choice of those people who are at REMA. It's not by choice. The commission must determine the functions of that committee. There's nothing that committee must do and that is not commissioned by the CRL, meaning the CRL commission must give that committee the script to follow, because it's a must. It's a must. They must do it. They must determine. And if that committee of people did something that was not commissioned, they became creative within that committee, it's violation of section 22:2A, because the Act says it is the commission that must determine the function of that section 22 committee. And secondly, a member, B says the commission must appoint a member of a committee as the chairperson. That's why Professor Musa Tulu, it is the commission. It was a must. It's a commission that appointed him as the chairperson. And C, to show that that's the committee of the commission. C says it may remove a member of a committee at any time, as much as they were there at REMA. The commission has powers to remove any person from that group of people at REMA. And number 4, it may determine a committee's procedure, even in how they do things. The language there of the Act says it may, meaning it may and may not. At least there, they have a leeway. But where issues of function meaning what to do, it is the commission that must tell the Section 22 committee what to do. It is the commission that decides who's the chairperson. And where the commission feels like we are not happy with any member, they may remove people. Now, if that body is independent, how is it that the commission appointed the chairperson? How is it that the commission came up with terms of reference for them? The reason it was the commission that came with terms of reference and appointed the chairperson is because it's the committee of the CRL. It's not independent. So it's a lie to say this is an independent body. It's not an independent body. Yeah, let me show you again. Before we go to section 22.1. Now, on delegation of power in section 23.1a and Roman figure number 3, it says the commission may delegate any of the commission's powers to a committee of the commission. Now, we are told of a committee of the commission. Now, remember what section 22 is, or where in the Act speaks of the commission appointing a committee. Provision for setting up committees of the commission is in section 22. But section 23 says the commission may delegate any of the commission's powers to a committee of the commission. You'll see every time, where reference is made of the committee, it's referred to as the committee of the commission. Any committee that is not of the commission, it's a community council. It's a community council. It's a community council. Now, let me see where we see evidence to show you that it's a committee of the commission. You've seen it for yourself in 23. 1 A and then Roman figure 3. You saw it for yourself. You saw it for yourself there. But if you go down, but in the interest of time, I would show you another place where it's referenced. It's referenced there in the Act. Because when you see, it's there in 41. In 41, 1A, 41.1, and then A says, a person commits an offense if that person willfully disrupts the proceedings of the commission or a committee of the commission. 41 there speaks of a committee of the commission. The question is, which committee is the committee of the commission? The answer is within the Act. And the answer, when you want to know what is the committee of the commission, the committee of the commission is the section 22 committee. So those REMA people called, if they accepted, that label to say they are an ad hoc committee, section 22 ad hoc committee, section 22 ad hoc committee, they simply accept in terms of the Act that they are the committee of the commission. Now let's wrap up by showing you something there. Then that will be the end of this part 1 of this conversation. Now, on committees, remember the heading there says operation of the commission. Now, 22 says 1. I read you 2. I've shown you from 2 that it's the commission that determines the function of that committee. Secondly, is the commission that appoints. Commission has the power to remove people from that committee. Those people you saw at REMA, commission can remove them. And commission can disband that thing because it's theirs. They can disband it because it belongs to them. It's part of their operations. Any idea that is said, hey, no, these are independent. Those people are not independent. They are the commission. They are a committee of the commission. Now, here's a problem with that committee. Here's a problem with that committee as I wrap up, according to section 22(1). Yeah, and 1A and B. It says, if there's a need in the operations to establish a committee, 22(1) 1A says, the commission may establish one. You see that word establish. So it was the commission that established. And once the commission dissociates itself from that group of people and say these people are independent, it means they have established, a community council. And in terms of the law, it's unlawful because it's a contravention of the act. It's an unlawful move because they would have established a community council. And the act did not tell them to establish nothing. But once it's a committee of the commission, they have powers to establish it, empowered by the act. Now, this is how it works. It says the commission may establish one or more committees. Now, here's how those committees must look like. And that is something I need you to refer to. And visit the CRL Commission's website to check in terms of establishing that committee. They've written something there on how that thing was formed. If they edited it, just go to that REMA part where, the commissioner, I think it was Dr. Mafadza or whether it was Mamkaluva who was making that presentation. Follow it on your YouTube. You will see what I'm talking about. If they've edited it from the website, then you can't take it away from that YouTube on that establishment at Rema there. It's there in black and white and so on. It's an error. I saw last time in Parliament, they've edited that slide, but the information on, they've edited the Parliament version of the slide. And then, but now the REMA one, you'll see that slide where it speaks of section 2022 and where they quoted it, you'll see what I'm talking about. And then as well as if you can go to the website, the CRL Rights Commission website on the establishment of the committee, look at that heading, you'll see what I'm talking about. As I read this, compare what you will see there to what I requested us to do from the Act. It says it is the CRL. The first thing we need to understand about the Section 22 committee is that it is established by the Commission. And then secondly, the composition of the people who must be in that commission. It says consisting of, number one, members only. If it's a CRL established committee and it should have members only. That's the first thing. Meaning, if it's a Section 22 committee, people who must be in that committee are members of the commission only. Meaning, they are commissioners of the commission that were appointed by the president only. Alternatively, you'll see the word there, it says or, meaning if it's not commissioners only, who are members of the commission, then alternatively, or members and staff or other persons. If you don't have members only, it is members plus staff or other persons. If the reading there now, because for the purpose of those who will follow later this, because I've requested that you download the Act from it's available, the CRL Act from Google, download it, go to section 22 so that you check where I'm reading. Now, it says it's members only. This is the language, yeah? Members only or, meaning alternatively, because the word or, it says alternatively. You can have this or that. So if you don't have this, you can have that. It says or members and staff. Members and staff or other persons. Then it puts a comma. Now, it says members and staff or. Now, between staff and other persons, there's no comma there. There's no comma. There's no comma where it says members and staff. Now, if you go to that presentation at REMA, you will see CRL Commission. They have put a comma after the word staff. And if you go to the Act, it doesn't have a comma after that word staff. It has a word or, not a punctuation comma. It doesn't have the punctuation comma after the word staff. So it means it's members and the staff or other persons. So meaning the option is between the staff and other persons. But at all material times, if this thing is to be a Section 22 committee, commissioners must be part of it. Now, if you go to that group of people that were at REMA, there's no commissioner amongst them. So, in terms of the Act, that's a bogus Section 22 committee. If we are to dignify that thing, let them at least call it a community council. But if they call it a community council, then they have contravened, they've cooked the Act to find their thing. That committee is not independent. Secondly, it's wrongfully established. So it's a bogus committee. It's bogus committee. Doing something it is not supposed to do. So this concludes part one of this conversation. Thank you for joining us. Now, in the next segment, we'll be looking at what is it that this bogus so-called ad hoc committee have done that draft thing that they were announcing a week or so ago. What is wrong with it? Then we'll take you through it so that you see it, on the errors that are in that document. Why this? Because Hosea chapter 4 verse 6 says, my people perish because of lack of knowledge. And because you reject knowledge, I can't trust you to be my representatives. So if we are to be effective ambassador, and disciples of this country, we must not allow ourselves to be ignorant. Go to your Google, use your data effectively, download that copy of the Constitution, download the CRL Act from Google, and check if everything I've talked to you, is it like that? Or am I being too excited? To verify, and I'm open for discussion as I will be, checking your responses, on your comments on this matter. But this is the end of the segment. And on the next segment, we'll be unpacking that document to show you errors that are in there, problems that are there. And now my problem is, when you see people with credentials and they write a document like that, it makes you wonder. It makes you question their credentials. Thank you, family, for joining this conversation. I know we've stretched a bit, but it's for the purpose, because sometimes these things take time so that we understand them, because I could not take it for granted that you maybe you have clarity on these things. But thank you for those who stayed with us, on this, segment and conversation. Thank you. Shalom.